Good afternoon, everyone, and thank you for joining us today for 25 Minutes with Cap. I'm Debbie Saphire, and I'm the Technical Underwriting Lead for Professional Lines at CapSpecialty. So in the next 25 minutes, we're going to take a close look at a couple of emerging risks that could specifically impact media liability. We'll focus on the challenges that may be present for insureds, brokers, and insurance carriers, and coming up with the right risk management and insurance solutions, including why limit management and rate adequacy continue to be important. We're excited to hear from a couple of CapSpecialty experts on media liability coverage and claims today, Mary Schust, who is Head of Media and Entertainment Liability, and Bill Roy, CapSpecialty's Head of Professional Liability Claims. I need to take care of a little housekeeping first by telling you that the content of this webinar is the property of CapSpecialty and is for informational purposes only. You're not permitted to republish, share, or quote from this webinar without the prior written consent of CapSpecialty. And this consent can be obtained by simply contacting marketing@capspecialty.com. So at last September's webinar, as part of our look at emerging risk, we started a discussion on the developing issues arising out of deepfakes. So today we're going to take a deeper dive into that discussion and also take a look at digital content ownership issues that may arise out of non-fungible tokens and the impact that both these emerging risks could have on media liability coverage. We have a lot of information to get through, and it'll most likely take up the 25 minutes. But if you have questions, go ahead and drop them into the chat, and we'll try to answer today, or we'll gladly reach out to you after the presentation if we do run out of time. So let's go ahead and get started. Good afternoon, Mary. It seems like the world that we live in today is what we used to think of as science fiction. And with rapidly developing artificial intelligence, it's hard to stay on top of all the new exposures presented by new AI like deepfakes. Can you give us a brief description of what a deepfake is?
Thanks, Debbie. The term deepfake is a combination of two very ordinary words, deep and fake. Here, deep refers to the artificial intelligence technology that's involved, which is often known as deep learning. Deepfake technology is used in synthetic media to create falsified content, replace or synthesize faces and speech, and it can even manipulate emotions. A person in an existing image or video can be replaced with someone else's likeness, and it can be used to digitally imitate an action by a person that they didn't even commit. Although the creation of deepfake programs is really not mainstream, it's managed to get a lot of attention in the media space. Some good ways it's being used is deepfake visual effects technology will significantly reduce the amount of time and cost in creating content. It will fundamentally change how media is created in the future. An example of how it is negatively being used is in deepfake porn videos. Female actresses have fallen victim to deepfake porn where their faces have been digitally placed on videos of porn stars in a very realistic manner. It can also be a sinister way for people to blackmail or denigrate others. One example involved a mother who created deepfake photos and videos of her daughter's cheerleading rivals, doctoring their images in an attempt to get them kicked off of the squad. Fortunately, in that case, the family of the victim contacted the police early on and her plan was stopped.
So this really is what we used to think of as science fiction, but it's now part of our everyday world. Mary, you touched on some good or beneficial ways that deepfakes are being used, but you also mentioned a couple of concerning scenarios with the fake porn videos or deepfakes being used to denigrate others. And the example you gave of the mom going after her daughter's cheerleading rivals is especially disturbing. So this can be really serious activity that can create real and significant harm. I can only imagine the other types of litigation and claims that we will start to see from the abuses related to deepfakes. Bill, what are we starting to see out there as far as deepfake related cases that we should keep on our radar?
As far as media liability exposures go, copyright litigation involving deepfakes is naturally one of the primary concerns. One of the more prominent deepfake cases over the past year is involved JayZ and his entity Rock Nation. Rock Nation's sued Vocal Synthesis, which is a neural network, and an anonymous creator of Vocal Synthesis wound up receiving a copyright claim on YouTube from JayZ arising out of 2 videos with deepfaked audio of JayZ reciting the to be or not to be soliloquy from Hamlet and Billy Joel's We Didn't Start the Fire. JayZ demanded the videos be taken offline, contending that the videos were an infringing use of his copyright and that the videos unlawfully use artificial intelligence to impersonate JayZ's voice. Now, the deepfake audio clips were created by training a model using a large database of audio samples and text transcriptions, and then feeding JayZ songs and lyrics into a neural network, which is a computer system modeled on the human brain and nervous system. Now, from a copyright perspective, the model and audio generated from the copyrighted audio recordings would likely be considered derivative works. However, whether there is an actionable claim for copyright infringement depends on how the work was being used and for what purpose. Here, there's a strong case to be made that this derivative work should be protected fair use. A court in weighing a fair use defense would look at the purpose and character of the use, the nature of the copyright work, the amount and substantiality of the portion taken, and the effect of the use upon the potential market. In this case, the deepfake would likely be considered transformation. None of the original work is used in any recognizable form. It's clearly designed as a parody with an intent to entertain and poke fun of and not to deceive. Further, in this case, Vocal Synthesis is an anonymous and non-commercial project without paid advertising and no clear financial benefit to the creator. Nonetheless, the JayZ videos in this case were in fact taken offline. Thus, while fair use might be a successful defense in such cases, ultimately, it won't protect you from getting sued in the first place, and the cost of litigating such cases can be quite high.
Well, these are certainly some very high-profile cases where, yeah, I can see litigation costs could be very high. Mary, can you tell us about the media liability coverages that could come into play in deepfake-related claims for more traditional insureds that we and the brokers see every day?
Yes, Bill's example involved a large studio and celebrity, but these kinds of situations can also affect small independent film studios or production companies that we could insure. This was not our claim, however, but this past year, a defamation claim was filed against Ryan Seacrest Productions in the Bravo TV series called Shahs of Sunset by a fashion designer and a pop star, claiming that the defendants had created cheap fakes using technology to negatively affect her appearance. That lawsuit asserted claims for false endorsement, false advertising, and trademark dilution under the Lanham Act. Those types of claims would be defended under most media policies. The suit was ultimately dismissed in that case on various grounds, stating that the alleged infringement was part of an expressive work protected by the First Amendment. Most deepfakes are not illegal, and they are considered protected free speech, which was the case in the example that I just spoke of. However, there are some other types of claims that could also trigger coverage. Defamation claims can be brought. Donald J. Trump for president brought a defamation claim in connection with a TV ad that they claimed contained synthetically altered material. That type of claim might be brought against the ad agency who designed and developed and produced the ad, and or the advertiser whose idea it was in the first place. Right of publicity claims can also be triggered if the use of a person's likeness is used as a character in a production or a video game. In this kind of case, the plaintiff can allege that the defendants used his likeness without his consent in violation of his right of publicity. These claims are often filed against film producers and game developers. Copyright claims are more difficult to prosecute because the fair use defense could be applied, and deepfakes are inherently an alteration of something else. However, an example might be a video production company or an ad agency who recreates art out of archival footage. to be used to attract visitors to a museum when those exhibits don't even exist. So as you can see, many times the defendants win these cases. However, like Bill says, the cost of defense can be very expensive.
Okay, so there are several traditional media liability coverages that could be triggered in defensive claims for all kinds of insureds. You mentioned advertisers, ad agencies, film producers, game developers, and I'm guessing marketing and PR companies could also become involved in a deepfake claim. There are so many applications available to easily create deepfakes, and they range in all levels of sophistication. So if you combine the ease in creating a deepfake with the ease and everyone's seeming willingness to share this type of content, it would seem that exposure to deepfake claims will only continue to increase. So let's move on to another developing use of technology that may present new issues in digital content ownership. I'm speaking about non-fungible tokens, or NFTs. Mary, can you help us understand what an NFT is and how it works?
A non-fungible token, or NFT, is a one-of-a-kind asset or unit of data recorded and stored using blockchain technology. Each NFT contains a unique identification and metadata in digital form which can't be interchangeable and represents an image or an electronic deed to a piece of property. NFTs can be used to represent photos, artwork, videos, audio, or really any other types of digital files. Those NFTs can then be bought and sold on marketplaces that are linked to the underlying block technology. Some notable examples of NFTs have been the sale of an NFT that represented the original source code for the World Wide Web, which sold for $5.4 million, and the first tweet of Twitter's CEO Jack Dorsey that sold for $2.9 million. The most expensive NFT artwork to date has been Beeple's JPEG work called The First 5,000 Days, which was a collage consisting of 5,000 digital images that he created since 2007, and that sold for $69 million through Christie's. Sports NFTs, such as Top Shot Moments, are also going for large sums of money. An NBA Top Shot photo featuring LeBron James emulating former LA Lakers Kobe Bryant's reverse windmill dunk sold for nearly $400,000 at auction last April. So as you can see, celebrities, creators, and athletes are all utilizing NFTs to monetize digital creative works and other experiences.
So again, with the high profile and high dollar nature of NFTs, it would follow that we may expect to see some expensive litigation that could tend to drag out for a while. Bill, can you tell us what you're seeing in NFT related litigation?
In the context of potential media liability exposures arising from NFTs, we first need to address a few fundamentals concerning NFT copyright ownership. Absent terms stating otherwise, ownership of an NFT does not entitle one to the ownership of the digital asset, the underlying artwork, or any other object. Ownership of an NFT also does not, by default, grant any rights to the intellectual property of the underlying asset. The author who created the work initially owns the copyright in their work unless and until they transfer ownership of the copyright in writing to someone else. So unless the NFT includes a transfer of copyright in the underlying asset, then the author, not the NFT holder, owns the copyright. Further, the NFT itself will likely not be protected by copyright. That is, NFTs typically comprise a ledger or record of ownership on a blockchain and a link to an underlying asset. Thus, unless an NFT embeds the underlying asset itself, which most don't, the NFT itself is not protected by copyright. Consequently, we've seen litigation surrounding NFT copyright ownership heating up over the past year. And not to pick on JayZ, but he seems to be one of the more active protagonists seeking to enforce his rights in the digital universe. JayZ's entity, Rockefeller, sued Damon Dash in the U.S. District Court for the Southern District of New York. JayZ, also known as Sean Carter, is a one-third owner of the shares of Rockefeller. The other share owners are Kareem Burke and Damon Dash. Now, Rockefeller commenced suit against Dash in June of last year, seeking to stop Dash from auctioning off the copyright to JayZ's debut album, Reasonable Doubt, as an NFT. Rockefeller says that while Dash holds a 1/3 stake in the company, Rockefeller Inc. owns the album, including the copyright and all rights, title, and interest to and in reasonable doubt, including the right to sell, record, reproduce, broadcast, transmit, exhibit, distribute, advertise, and exploit the album. Dash, according to Rockefeller, has no individual interest in reasonable doubt, and as such is attempting to steal a company asset minted as an NFT and auction it off. Among the causes of actions asserted by Rockefeller was a claim for declaratory relief, seeking from the court a declaration that RAF Inc. owns all the rights to reasonable doubt, including its copyright, that Dash, as a shareholder, has no direct ownership interest in reasonable doubt, that Dash is not permitted to sell any interest in reasonable doubt, and that Dash must transfer to the company any NFT or other asset in his possession, custody, or control reflecting rights to reasonable doubt. Now, while the case remains pending, the court did issue an order restraining and enjoining Dash from altering in any way, selling, assigning, pledging, encumbering, contracting with regard to, or in any way disposing of any property interest in reasonable doubt, including the copyright thereto by any means, including attempting to auction an NFT reflecting, referring, or directing to such interest. Now, another more recent piece of NFT litigation involves Miramax suing Quentin Tarantino in the U.S. District Court for the Central District of California. In November of last year, Miramax filed suit against Tarantino, seeking both monetary and injunctive relief, alleging that Tarantino is liable for breach of contract, copyright infringement, trademark infringement, and unfair competition arising out of a pulp fiction NFT. Miramax contends that Tarantino is eager to cash in on the NFT boom when he announced plans to auction off 7 exclusive scenes from Pulp Fiction in the form of NFTs, each NFT being marketed as containing one or more previously unknown secrets of a specific iconic scene from the film. Miramax argues in the complaint that the company, not Tarantino, owns the rights to the film and the screenplay, and that they were forced to sue Tarantino, a valued collaborator, in order to enforce, preserve, and protect its contractual and intellectual property rights relating to one of Miramax's most iconic and valuable film properties. Now, Miramax contends that when they signed the contract with Tarantino in 1993, he signed over the rights to the film with the exception of certain reserved rights. Those reserved rights include a clause saying that Tarantino has the rights to, quote, print publication, including without limitation, screenplay publication of the film. Tarantino's lawyer argues that his proposed NFT sale falls within the screenplay publication of the reserved rights clause. Naturally, Miramax argues the opposite, claiming that the sale is a one-time transaction, which does not constitute publication. The complaint also mentions that Miramax itself hoped to sell NFTs from the film and that Tarantino's venture impairs them from doing so. Thus, while the suit is still in its infancy, it would be surprising if Miramax and Tarantino didn't come to settlement terms sooner rather than later, given the potential significant litigation expense that both sides will incur if this litigation moves forward.
Well, it'll certainly be interesting to follow these two cases and see what the final outcome is. So let's go ahead and turn to the subject of how the government is reacting to these issues through regulations or legislation. What are we seeing as far as regulatory controls or limitations on the use of deepfakes and NFTs? Bill, you want to tackle this one?
In regards to deepfakes, much of the regulation concerning deepfakes thus far has been limited to instances of pornography and elections within states criminalizing certain activity, such as Virginia made the distribution of non-consensual, falsely created explicit images and videos a Class 1 misdemeanor, punishable by up to a year in jail and a fine of $2,500. In the case of candidates for public office, Texas makes it a Class A misdemeanor, punishable by up to a year in the county jail and a fine of $4,000 for a person to, quote, create a deepfake video and cause that video to be published or distributed within 30 days of an election if the person does so with an intent to injure a candidate or influence the result of an election. From a civil law standpoint, California enacted 2 laws that collectively allow victims of non-consensual deepfake pornography to sue for damages and to give candidates for public office the ability to sue individuals or organizations that distribute, quote, with actual malice, election-related deepfakes without warning labels near Election Day. Further evolution towards meaningful regulation of deepfakes, however, is an uphill battle, likely subject to substantial First Amendment scrutiny. But so far, there are few legal protections in place and even fewer legal precedents.
Okay. And what about regulatory changes for NFTs?
As far as copyright is concerned, we'll have to see how some of the civil litigation plays out and whether a groundswell is created thereby to attempt to address any perceived shortcoming or deficiency in existing copyright law. On the face of it, copyright law in the U.S. is well developed and is empowered to protect the artist behind the digital collectible whose metadata is linked to the NFT. The Digital Millennium Copyright Act, which amended U.S. copyright law, provides for legal protection against unauthorized access to copyright owners and makes it unlawful to provide false copyright management information. Section 512 of the Copyright Act enables copyright owners to have infringing material removed and shields online service providers from liability. Using the notice and takedown system, the copyright owner can make a request to an online service provider to remove material that infringes their copyright protected work. Section 1201 of the Act prohibits circumventing technological protection measures used by copyright owners to control access to their works. And Section 1202 makes it unlawful to provide or distribute false copyright management information.
Okay, Mary, would you like to add anything here on the regulatory front?
Well, there is really no direct state regulatory guidance on NFTs, though a few states have created laws that could affect them. The current U.S. regulatory and legal framework is slowly catching up with the technology. Key legal issues include how NFTs can be categorized, intellectual property rights, anti-money laundering and sanction implications, cybersecurity concerns, and state laws governing virtual currencies. It's complicated, though, because by their nature, NFTs can be linked to a variety of different assets and can be difficult to classify. If an NFT is considered a security, then common securities law applies. However, if they are considered a commodity, then the Commodity Exchange Act may apply. The Commodity Futures Trading Commission has recently issued an interpretation of these digital assets, so it will be helpful in considering these issues going forward.
Okay. So we've got new exposures, we've got potential for claims, and we've got evolving regulations. So the insurance industry will have to find a way to address the exposures arising from deepfakes and NFTs head on. Mary, are you seeing any movement in how the media liability market may address these, either through coverage or additional exclusions or some other way?
As to both of these types of technologies, most media policies have a broad definition of content. It might be defined as information in any form, whether it's in writing, electronic, or otherwise, and it'll include pictures, film, digitized content, graphics, artwork, and really any other data. In the event of a claim that arises out of the actual content or protected image, a carrier may be obligated to provide a defense. However, there are normal exclusions, or there normally are exclusions, that would exclude the monetary valuation of any types of securities or tangible property, such as these NFTs. Rates have been increasing on media policies due to emerging risks as these and the fact that there really are no clear dispositions on any of these issues, at least for now. Underwriters will continue to evaluate an NFT and deepfake exposure and make evaluations on the depth of the content and the insurability.
Okay. Well, looks like we're close to the 25-minute mark, but I'd like to close this out by hearing from both of you your thoughts on what brokers should tell potential insureds, or what are some key things that brokers should look for in an applicant who may somehow be involved in these emerging risks? Or what steps would an insured take to limit their issues arising out of deepfakes or NFTs?
First and foremost, for an insured to know where their content is coming from and who is creating it. Secondly, have counsel evaluate for any fair use defense that might be available to them. In ferreting out deepfake exposures, there's certain best practices that can be consistently employed, such as the use of detection software, manually checking for questionable video, image resolution quality, inconsistency with lighting and shadows, and whether there are any lip syncing problems with audio streams.
Okay. Mary?
Yeah, the only other thing that I would add is that as the market for content expands, intellectual property rights holders really need to be diligent in protecting their work.
Mm-hmm.
And NFT platforms will need to remove content if they are notified of an infringement. Each situation will need to be analyzed to determine if the content is free and clear to use, or if there is a derivative, or if it's a derivative of another work. It won't always be straightforward, so a full analysis will be necessary.
Okay, well, that looks like our time for today. I want to thank you all for joining us, and thank you to Bill Roy and Mary Schust for providing some great insight into these emerging risks in media liability. To all of you, we at CapSpecialty appreciate your support and encourage you to keep an eye out for an invitation to our next edition of 25 Minutes with Cap. That should be coming out shortly. So I'll just say goodbye from all of us for now.